Good morning. Thank you for joining us today. My name is Alexis Eykel, and I'm the Landlord Engagement Specialist at Tacoma Housing Authority. And today is the final presentation of the City of Tacoma Rental Housing Code updates. And today's presentation is going to be about shared housing. And today we are joined by Housing Justice Project, Lori Davenport, Wyatt Fisher, and Chiquata Elder with City of Tacoma, and Jim Henderson as well. And they're going to go ahead and kick this presentation off for us. I do want to acknowledge that I think today is 3 years that we've been doing these presentations together. So thank you, Housing Justice Project and Jim, so much for doing these presentations for our landlords to understand the legislative updates and rental housing code changes as well. And this is just such a special partnership that we've had. We've been able to work through a lot of different topics and to just help each other better understand what's going on. And so I'm going to go ahead and turn it over to Wyatt.
All right, thank you, Alexis. So let's get started. As always, we just want to include the disclaimers that there are going to be some ballot measure, or there's a ballot measure that will be on the November ballots that may or may not affect the rental housing code. So this only refers to changes that were made on July 11th, which came into effect July 24th. So there might be additional ones down the line, but for now, this is the law. Additionally, we're not providing any legal advice. I know that specifically some of the questions around shared housing in particular might kind of lean towards the legal advice side of things. So we'll just need to be a little careful about that. And I apologize if there are some questions you have that I'm not able to answer. So first, I think it's really important that when we talk about the shared housing that we point to what the city's stated intent was in passing this new section of the rental housing code. Chiquata, would you like to speak on that at all, or would you prefer me to? You prefer me to? Okay. So basically the city recognizes that shared housing, basically where people are coming together, not necessarily as a family, but they are renting out a dwelling unit and separating out into individual rooms and then sharing typically bathrooms, kitchens, things like that, is a really important tool in reducing homelessness and reducing rents for people, because as we all know, things have gotten really expensive in this region. And so the city recognized that although that is a very important tool, there are a lot of risks that come with those sorts of arrangements as well. And so this new section is kind of aiming to provide additional protections and better clarify how shared housing should look in the city. So broad-based brush, any landlord or master leaseholder, and we'll get to definitions of what that means in a second, but any landlord or master leaseholder renting to 4 or more tenants in a dwelling unit must have separate written rental agreements for each habitable space. So there's a lot of different terms that we'll need to define, and that'll be the next slide. But keep in mind that 4 or more tenants in one dwelling unit, they must have separate rental agreements. Those rental agreements must be written for each habitable space. Additionally, a master leaseholder, which we'll go into who is a master leaseholder, must provide contact information to any of their subtenants to the property owner, and then provide contact information of the property owner to their subtenants. That's again just to provide additional protections and make sure that tenants and landlords and master leaseholders remain in communication with each other, minimize any surprises that might come down the line. So relevant definitions, I would encourage you to maybe take a screenshot of this, refer back to it. Broad-based brush, shared housing means group housing, which is defined in a different section of the Tacoma Municipal Code, but it includes basically when a tenant rents a private room or a shared room in a dwelling unit, but shares the common areas such as a kitchen, gathering spaces, or bathroom. That's kind of what I said previously. Now, what's a habitable space? Habitable spaces are spaces that are structures for living, sleeping, eating, or cooking. So bedrooms, kitchens, there are probably other good examples, but things that do not fall under habitable spaces are going to include bathrooms, toilet compartments, closets, halls, storage spaces, attics upstairs, if it's not an actual bedroom. And you need to make sure that you're double checking under TMC 2.140W that if you aren't sure, you need to like really take a look at that. But broad strokes, it's living, sleeping, eating, or cooking spaces are habitable spaces. A rental agreement is a lease. Any rental agreement that establishes or modifies terms, conditions, rules, regulations about the use and occupancy of the dwelling unit. So even if you had a verbal rental agreement, that's still considered a lease. But for shared housing, you are required to provide a written rental agreement. A master lease is a rental agreement between a landlord renting a unit to a master leaseholder. And so then that raises the question of what's a master leaseholder, right? These next two definitions kind of point that out. Basically, a landlord is the owner, lessor, sublessor of a dwelling unit. Essentially, if you are the landlord, the top level landlord, or you're a master leaseholder that's subletting out to people, you are also considered a landlord if you're a master leaseholder. And then a master leaseholder is someone who has a rental agreement with the landlord of a dwelling unit with the intent of renting the dwelling unit to one or more subtenants. So there, as we kind of, on that last slide, I'll go back real quick. On that last slide, any landlord or master leaseholder renting to 4 or more tenants must have separate written rental agreements. Not every master leaseholder is going to fall under that requirement. So you need to pay attention to how many tenants you have, what your status is as a landlord or master leaseholder, okay? A tenant is any person entitled to occupy a dwelling unit primarily for living or dwelling purposes. So that includes not just people that are paying rent, but anyone else who has a right to occupy the unit. And then a subtenant is someone who's renting from someone who else is renting, basically. So if there's any questions about that, we can kind of circle back around at the end, because I know that those can be kind of specific, how they would apply to individual scenarios. And I'll also point out we're going to go over some examples. A very key new requirement under the shared housing requirements is the notice to terminate tenancy. For a landlord to terminate a tenancy, they must serve the notice to the master leaseholder and provide enough copies for the maximum number of residents allowed under TMC 216B and W. Again, that kind of goes into the legal advice side of things. So I can't advise you on how many that maximum number is going to actually be. So I do encourage you to take a look closely on what those requirements specify for your unit. And then additionally, they need to be served in accordance with typical notice requirements for unlawful detainers. So most landlords, I think, are kind of familiar with that, but if you're not, definitely be sure to take a look at RCW 5912-4D and TMC 195-30C. Okay. So the main thing basically is that a landlord has a responsibility to notify, to provide notice to their master leaseholders so that the subtenants actually are going to be able to get notice as well. After being served notice under 195-70, the master leaseholder must serve copies to the subtenants. So it's not the responsibility of the main landlord to serve to the subtenants, it's the master leaseholder's responsibility. But if the master leaseholder, for whatever reason, fails to serve notice to the subtenants, the top level landlord would still have the right to pursue an unlawful detainer action and ultimately evict the subtenants. But there are additional protections for those subtenants when they haven't received notice from the master leaseholder. Specifically, the law states that the subtenants who didn't receive notice would get an additional 30 days following the date of the writ of restitution being issued before they would have to vacate.
I'm just gonna, I think it is, it is best practice that you do serve the subtenants as the person serving the notices. Don't rely on the the master leaseholder to do that work. Because if you do, as White said, there could be an additional time given to those occupants. So you should, and I think also it allows them to get the information as timely and to be able to start having a discussion around the impact of that notice or the circumstances that, and as we'll talk about examples later, but there could be circumstances that you might want to be aware of that you may not be aware of as the owner of the property.
Thank you, Jim. That's definitely important context. And yeah, I'm mostly providing overview, and then you can provide the advice. Okay, so we have a few examples here. Example number one, just to kind of give a sense of what this actually looks like. So let's say Albert owns a large home with 5 bedrooms, a kitchen, a dining room, and a living room. And then that living room is connected to the kitchen by a wide hallway. Albert rents it out to Bertha. So Albert's the landlord, Bertha's a tenant, right? The rental agreement. I apologize. I think
She'd be the master leaseholder.
Right. I apologize. That third line is not correct. So Bertha would want to rent out the sub. Let me backtrack. My apologies. Albert's the landlord, Bertha's the tenant. Bertha decides she wants to rent out some of the rooms to subtenants. Okay. The rental agreement between Bertha and her subtenants would be the master lease, and she would be the master lease holder. I apologize that is written wrong. Both Albert and Bertha are considered landlords under the TMC, and both are required to comply with city business license requirements if they wanted to evict their tenants or raise the rent. Okay, so the master leaseholder is Bertha, and she's required to provide separate leases for each habitable space in the house that she's renting out. So if she wants to keep one of the rooms to herself, she doesn't have to provide a master lease or a rental agreement for that room. But any tenant who is renting a room, she could make a separate lease for them for that specific room, plus whatever shared spaces they're allowed to have access to. So this provides additional clarity to tenants. And Jim, it looks like you have a look in your face like maybe I'm saying something wrong, so feel free to jump in. Okay. So this provides an opportunity for a master leaseholder to share their living space with subtenants, but also still make it clear about which spaces they're actually renting out. That's kind of the main key takeaway of this one. So Bertha, Carl, Dave, Elise, and Frank might all be on the leases for the kitchen, dining room, and living room. And then the 4 subtenants might have their own leases for their bedrooms. The wide hallway isn't a habitable space, and so it doesn't get a rental agreement. So it's a lot of paperwork, but ultimately it's going to reduce ambiguities for each tenant and subtenant in terms of their rights and responsibilities as it pertains to the dwelling unit. Sequeda, yes?
Again, just to, because I know like reading that, it sounds a little tricky. I think the main thing is that you're like the Jim or Carl, I was trying to use one of your people. Carl is renting out his bedroom. And I think the main thing is like we're not trying to, like, you don't have to list like the hallways and stuff like that. I think the city's intent is we don't want people changing like a closet into a bedroom or a basement that hasn't been, with proper egress, or people putting people in the garage. So we're not trying to make it to where you have to list out like everything, like a person can't sleep in the bathroom, but we just want to make it to where we're not having people sleep in spaces that aren't habitable or humane, because we've seen some of that. So yes, I just wanted to kind of clear that up, because it sounds like we're just trying to be difficult, but there's a reason behind it. Yeah. Mm-hmm.
Well, and I'll add to that. I think that in this type of housing, you can't be clear enough. And you particularly when you have unrelated people sharing common space, you need to be really clear on what the expectations are for how that space is used, so that you have something in which to refer back to when potentially one of the occupants of the home is not meeting that expectation. I think this is in this scenario that Wyatt put together, this is not uncommon. And I think too, the other kind of takeaway here should be that you want the relationship between each person to be very clear. And you want, what is Bertha's role? And I think between Bertha and Albert, if you're Albert in this scenario, you want to make sure that your lease allows and that you're giving permission for Bertha to use the home in the way that this scenario lays out. Your lease should allow her to sublet. So if so sometimes this is where you will need legal advice. A standard rental agreement that you can get from one of the associations, or that you may, you access, it typically doesn't allow subletting. That's kind of a general rule that you're not allowed to sublet, primarily because Albert wants to know who's living in the home, and doesn't want it overoccupied, doesn't want people in there that he's not aware of, who he's agreed can live there. Now, so you want, if you're Albert, you want to make sure that your lease allows for Bertha to operate, and then you want to be aware of what Bertha's doing and making sure that Bertha also is licensed, and Bertha, has a rental business license, and that Bertha also understands the rules around the information that every rental agreement in Tacoma has to have. Again, to make sure that it's not overoccupied, she's not renting out spaces that aren't intended to be used. So there's a very clear, this is a very different transaction, a very different relationship and how you manage it as opposed to when it's just, a non-sublet agreement.
And I just wanted to throw in there too, and Jim, thank you, you brought up a very good point. It does make it clear between the owner and the master leaseholder, but then it also definitely protects the owner too, because like if the owner has someone in there and they haven't given permission, it helps them be able to get that person out because they violated their rental agreement. And then it also helps the owner too, because if you have someone who's just willy-nilly renting spaces in your property, and then like code enforcement goes in, they're not going to go after Bertha because she's not the owner. They're gonna, the citations and the violation goes to the owner of the property. So by you putting in there and making it very clear to Bertha, these are the spaces that are habitable. I'm giving you permission to sublet. You can't sublet these spaces, or you can't just change anything into a sleeping space or, a rented space. So it protects the homeowner, because we see that a lot of times too, where the homeowner will get a violation and they haven't even done anything, but it's because of the actions of the person that they rented to.
I think I'll add also to that, because Chakota brings up a good point about, I think the occupants who are under Bertha, well, they're probably paying Bertha the rent and then she's forwarding it on to Albert. What about when she doesn't forward it? You pay Bertha, but Bertha doesn't pay Albert. So now your housing is at risk because she didn't pay the rent. That's again where you want Albert and the occupants to know of each other. And everybody needs to be clear on this relationship so that when something happens and there's people have access to one another to sort it out and to be clear.
Yes. So that covers, I think, a lot of what is kind of being anticipated with this new section of the law, but just some other examples. Thinking about roommates and specifically students. So if you think about, there's a apartment complex on Hilltop. Incoming UW-Tacoma freshmen want to live together, 4 of them. So it implicates the shared housing requirements. The homes, the apartment complex offers 1, 2, and 3 bedroom homes. So even though it's only a 3-bedroom home, because there are 4 tenants, they still implicate the shared housing requirements. Now the roommates and the landlord can decide whether all 4 tenants are going to share responsibility for the entire house or for the entire apartment, or if they want to be more specific and specify that one roommate has access to this apartment or this room, another one has access to this room, another has access to this room, and then they all share the kitchen and living room. That's up to the landlord and the tenant. So this is kind of to specify that you don't have to separate them out. If roommates want to share responsibility for the entire apartment, they're welcome to do so. And the other thing I wanted to point out with this one is that there's no master leaseholder here, because there's no like subletting going on. And so there are certain requirements under this section that do not get implicated.
Just a reminder that if you use this, format, like sometimes, it's easier to have each occupant in a situation where they're unrelated, but they're all kind of coming in together because they have a shared, purpose. Sometimes it can be easier to have them on separate ones so that as as those occupants need to change their housing situation, whether they're one graduates, one moves, or it makes the in and out a lot easier. When you have everybody on one, you've collected a deposit for the unit, and that becomes the hard part to try to trade out the deposit. I think another reminder that under the city's new tenant screening rules, again, if these three people are coming in together, they could assign the financial responsibility to one of them on that lease. So that's another thing is, and then what's the likeliness that all three stay together during the duration, or that somebody, or renew together. So those are considerations when trying to decide which way to assign or to move them in.
Chiquita, you're muted.
I thought I unmuted twice and it didn't do it. I just kind of wanted to piggyback off two things that Jim said. One of the reasons too that a landlord might want to consider putting people in on the separate leases, especially in like these kind of like student things. We see this a lot where one student like stops paying their rent, and then you have everybody on there, or one person becomes destructive, and the landlord and everybody knows who that one tenant is. And if everybody's on one lease, the landlord is pretty much forced to evict that whole household, versus if they're on separate rental agreements, they can just go after that problem person that they know. So that gives the landlord that protection. And then also some of the other tenants, like when a person stops paying their portion of their rent, just different things like that. So another thing, like with what Jim was saying, like the financial responsible person, that was not intended for this section in particular. The intent was like when you have a household like a husband and a wife, where the wife might not work or whatever, and the husband might be the financial person. But if you have like 4 or more people living there, we are not saying that the landlord cannot screen everybody for financial responsibility to make sure that they take up that. So that's one of the things that kind of quirky, and it could be read that way, but we do not want landlords thinking that, or tenants. And when we're educating people, we're not saying, oh, well, we're going to put Jim as the financially responsible person, because none of us want to, be that person or whatever. But yeah, landlords are always still allowed to screen to make sure that the people that are living there, especially on these separate leases, meet the criteria to live there. However you guys have done that with student housing. Did I just mess that up? But yeah.
Just a clarifying question. Is the scenario where the group gets to assign financial responsibility limited only to married couples and maybe an adult child that's living with them?
Well, no, Jim, why you gotta put? I gotta get back to you on that question.
Okay.
Talk to our legal team, but no, but that's what kind of when we were thinking about the student housing, we weren't saying that they get to choose. It wasn't until one of you guys brought that to our attention, like, oh, it could be interpreted that they choose one student, to be the whole financial responsible person, and that wasn't our intent, because we know that that's not usually how it happens with roommates in that kind of situation. So, we're not taking away the landlord's ability to screen to make sure that everybody that's living in that unit, no matter however the incomes qualify, no matter how it breaks down, is that they qualify, if that makes sense.
Yeah, for the landlords, I mean, these are just considerations that you should be thinking about as you're deciding what is the best way to move people in, whether it's individual leases or it's a lease with everyone on there. These Chiquita brings up good points as to what may or may not work best for your scenario.
Okay, and one last example. So let's say you have a student who is renting out a 1-bedroom apartment on 6th Avenue from an older gentleman. And then over the summer, that student decided to sublet her apartment to someone else because she was going to study abroad. In accordance with the requirements here, Ginny is the one that's studying abroad, notified her landlord that she had a subtenant. At that point, it's the higher level landlord's responsibility to keep the contact information. In this case, I kind of pointed out an example where this kind old gentleman wrote it on a napkin and then proceeded to lose the contact information. So Ginny, the subletter here, who studied abroad, she's done what she needed to do. But in this case, the landlord, for whatever reason, didn't keep track of the information. Now he dies. The estate takes over the apartment and they want to sell the unit because they don't want to deal with being a landlord anymore. Now, they don't have contact information for that subtenant, right? So even though they don't have contact information for the subtenant, and Ginny, being studying abroad right now, is not going to have the opportunity to serve her subtenant with notice that that the tenancy is being terminated, the estate can still ultimately evict the subtenant. It just provides additional protections for the subtenant. In this case, it's 30 days following the writ of restitution being issued. So landlords, you're likely aware that can be a kind of a long timeline. So it would add an additional 30 days, but ultimately failure for a subtenant, for a master leaseholder to serve their subtenant with notice of termination is not going to bar eviction ultimately.
It's the most,
Oh, sorry, go ahead, Jim.
I should say the most common type of scenario that I see where this example applies is when someone rents a home from the owner, they rent it to an organization, typically a business. And the purpose of the business renting the home is because they have a contract to provide housing on behalf. So sometimes it's the Department of Corrections, sometimes it's for other purposes that, and so then they are staffing the home and possibly they're renting out rooms, and could be transitional housing. They're all different sorts of business models, but the model is I'm a business, I'm renting this larger home, I'm filling bedrooms, people are kind of coming and going. That's where you see the absentee subletter. The business that's running it doesn't actually, it's not a person who lives there in the home and sharing their home or their living space with other people. So here in a situation where you have an absentee subletter, again, if you're the owner of the property, you absolutely want to make sure that you again are spending some time to really understand and verify the business, make sure that you know if you needed to give legal notice, who you're giving legal notice to. There's a whole procedure when your tenant, if you will, is a business versus an individual. So take the time, get legal advice if this is the situation that you are setting up, because there's lots for you to know that unless you've done this before, that you don't know that you need to know and be able to manage this tenancy correctly.